In other news, now that recreational marijuana is legal, smoking now and again certainly shouldn't impact your job, right? Well, there is proposed legislation which would prohibit an employer from discriminating against a person because of marijuana use. But the whole issue, and this new proposal filed by State Senator Jason Lewis, is raising concerns for employers. I sat down with Mark Adams, the Director of Human Resources at the Employers Association of the Northeast, to find out more.
The Employers Association of the Northeast is a not-for-profit organization. We operate in Massachusetts, Connecticut, and Rhode Island, though we're headquartered in Agawam, Massachusetts. The purpose of the association is to assist our member companies with their HR needs and other needs to help them remain successful. We do that through a variety of different initiatives, through our helpline assistance, our HR consultative services, our training and organizational development assistance. We have a variety of trained professionals on staff to work with companies, both large and small, in a variety of different industries.
How many questions have you received since marijuana became legal in Massachusetts?
We've received countless number of questions from our members in a variety of different forms, whether it is through our helpline, whether it is through some of our training events, even our networking roundtables. We often find we have a lot of professionals who are really struggling with the issue. Not that they want to really intervene into the personal issues that employees have off-site and off hours, but the major concern really is companies making sure that they can continue to operate businesses in a safe manner, not only for making sure their fellow coworkers are safe, but also for the people and visitors that they might have to engage as well.
Okay, so there is a proposal that employees would not be able to discriminate against a person based on marijuana use in their private time that is before the legislature. How do you feel about that?
I have some concerns about it simply because of some of the technological limitations that companies face in trying to be able to evaluate whether or not people are impaired or not impaired when it comes to the use of marijuana. While it is great, of course, to have carve-outs in the bill that say that an employee is not going to be protected under the bill if they are indeed impaired, the problem becomes that under current technology, testing for marijuana is not indicative of signs of impairment. So what that really leaves for employers for options is relying upon the training of supervisors to identify signs of impairment. And while it's a best practice, of course, to get your supervisors trained, the fact of the matter is evaluating impairment for marijuana use is by virtue of looking at a variety of physiological and behavioral symptoms to help a look at that. And that's something certainly that's done on a case-by-case basis, looking at those factors collectively. The challenge then becomes someone could be using marijuana off-site and off hours and shortly thereafter come to work, and maybe they might have the odor of marijuana on their attire. Maybe they might even have the odor of marijuana on their breath. Well, if they're not exhibiting signs of impairment, should we just hold off and let them work? What if we let them work and then they later become impaired after we've initially evaluated them, but we didn't feel like we could intervene at that point in time out of concerns of the law if it became law.
Right, because you can be accused of
and then
targeting
they
them.
get into a workplace accident, hurt a bystander, or what have you, then are we as a business at risk because we unknowingly allowed them to continue to work out of concerns that we didn't want to face some retribution should that new law come into effect. So there are some challenges there for that as to how you handle that situation.
What about with alcohol, though? Like, I mean, certainly for years, employers have been dealing with, making sure that people are, working properly and not drinking on the job, not showing up to work, impaired. Certainly people who use marijuana would say, hey, listen, you've already been dealing with this for so long.
Well, and I think I would just respond by saying, first of all, we don't have any state bills that provide similar protections for off-hour, off-use of alcohol. Second of all, when it comes to testing for alcohol is more presumptive in showing signs of impairment based upon how short it stays in the system. So there are ways to better fine-tune and prove whether or not an impairment situation would truly arise that would allow you to take timely and responsive action to those situations. It's a lot harder when you deal with marijuana, and to impose, in addition to that, these additional protections that could only invite litigation, I think you're putting companies in a very difficult position of balancing out running the risk of trying to avoid litigation on the one hand versus putting workplace safety on the other. And I think this bill could compromise safety in the workplace.
A lot of people might say, but listen, you know what, if so-and-so is smoking marijuana on their own time, shows up to work, and it's not a big deal, you know, why should this even be a concern for companies?
Well, and I think for many employees, hopefully they do exercise good judgment and do not smoke at times that are closely in proximity to when their work shift might begin. I think the troubling aspect is there has been some studies out there where since marijuana has been legalized elsewhere, where that's not necessarily the case. So last month, the Seattle Times just published a report. They did a survey of 900 recreational marijuana users since the state of Washington legalized marijuana, and they found that 1 in 4 users either use marijuana on their way to work or at work. And I think some of that might be tied to the fact that it's been legalized and emboldening people, either rightly or wrongly, in terms of feeling that it's comfortable to use at any time, just like they might smoke a cigarette. So, you know, the question then becomes, what if someone's on their lunch break, off the clock, technically off hours, and maybe off site, and they decide to use marijuana during that time? And then they come back to work. Maybe they're not immediately impaired, but should that be protected? Should we be able to take some action? What if I'm working in a business setting where I might be open to the public and they come back with the odor of that? Am I going to be then precluded from taking action out of the scope of how this legislation is currently drafted? I think that creates some pretty challenging business questions that need to be answered.
What kind of challenges did you face with medical marijuana when that became legal?
Medical marijuana did express some concerns, but because of the Americans with Disabilities Act, as well as our own state fair employment practices law and some of the case law that came out by the Supreme Judicial Court with the Barbudo decision, I think there was more of a roadmap for companies to know where they could intervene, take a step back, and also engage the employee directly with the responsibility of trying to reasonably accommodate them. Because once an employer is put on notice that they are a medical marijuana user, it then puts the responsibility on the employer to engage in the interactive process. So the use of the marijuana then under those circumstances comes more front and center for that situation to be engaged one-on-one with employees as the time arises, as opposed to recreational use where there isn't a need to proactively put forth your use on that, and sometimes a company might be put in a difficult situation without being able to engage it.
And how are you advising companies now as they move through all of this and try to handle the different situations that might come up with their employees?
With regards to recreational use or medicinal use?
Recreational use, yes.
Well, first of all, I would tell you that when it comes to companies, they're all challenged with trying to attract and retain good talent. With unemployment at historical lows, I don't think companies are really wanting to spend the time investing in off-hour, off-site use. Certainly, we at the Employers Association have been recommending that companies do need to continue to train management, certainly set expectations on maintaining a safe working environment, and that's a central purpose of how they're going to operate, and make employees aware that while marijuana might be legal, that when it comes to coming to work impaired or under the influence, or maybe coming to work with the odor of marijuana on their person, on their attire, or elsewhere, that might create a disruptive experience in assisting coworkers or customers or clients alike, that those type of forms of action are going to be unacceptable. I think communicating on the topic early to try to eliminate any ignorance that employees might have as far as what rights they really have under the legalization of marijuana today, I think can go a long way towards alleviating a lot of those problems, and in doing so, make this type of legislation unnecessary.